Welcome to INN's Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Siddhi Jain. Today she is going to speak on strikes and lockouts under the Industrial Dispute Act 1947. She is from KES Shri Jayatilal H. Patel College of Law. So without wasting further time, I would request Siddhi to commence with her lecture. Thank you.
Greetings to all, I am Siddhi and today the topic of discussion is strikes and lockouts under Industrial Dispute Act 1947. Imagine a situation where you're a worker and you're facing issues at your workplace. Here comes in the term of collective bargaining, which gives workers and employers right to negotiate the terms with employers. If the employers don't agree with the terms of the workers, they go on strike. The right to strike is recognized globally. Article 19, subsection 1 of the Constitution of India, 1949, guarantees the protection of certain freedoms as fundamental rights. All citizens shall have the following rights. First, freedom of speech and expression, to assemble peacefully without arms, to form associations and unions, to remove freely throughout the territory of India, to reside and settle in any part of territory of India, and to practice any profession or to carry any occupation, trade or business. However, a strike is not recognized in the Constitution of India. The Supreme Court of India settled in the case of Kameshwar Prasad versus State of Bihar 1958 by stating that strike is not a fundamental right. Government employees have no legal or moral right to go on strikes. Strike is a refuse to continue working because of an argument with employer about working conditions, pay levels or job losses. A strike is a powerful weapon used by trade unions, other association or workers. It is a stoppage of work caused by mass refusal in response to grievances. The right to strike plays a very vital role. It is one of the most important weapons and effective weapons of the worker in its struggle with capital to secure economic justice. It also empowers the vulnerable workers to fight oppressive cases when no possible constructive option is left to them. Right to strike is considered an essential component of right to association. If the right to strike of the workers is denied, then the right to perform unions would be empty, right? The freedom of association cannot be fully exercised if the association is not able to protect its members' interest and achieve the objective for which it was formed. Right to strike is not only a significant right but an integral part of collective bargaining. Collective bargaining is basically a process of negotiation with the employment terms by the employer and employee. It plays a rightful role as an incentive for management and labor to get their differences settled. The two sides are compelled to make compromise and negotiate as to come to an agreement because of the hovering prospect of economic sanctions. Thus, the denial to right to strike amounts to violation of all these basic freedoms. As the common goal of safeguarding the interest of the worker cannot be achieved by either of them individually. The International Labour Organization adopted a resolution on January 28, 1993, and the 14th International Conference of Labour Statisticians adopted the interim resolution that replaced the former. The word strike was defined as a temporary work stoppage affected by one or more groups of workmen, with a view to enforcing or resisting demands or expensive grievances, or support other workers in demands or grievances. Now that we have a very basic idea of what strike is, let's go into detail and understand what strike is under Industrial Dispute Act of 1947. Under Section 2Q of Industrial Dispute Act, strike is defined as a cessation of work by body of persons employed in any industry acting in combination or a concerted refusal or a refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. Under the following situations as given under Section 22, on these grounds, the strikes can be considered illegal. That is, without giving the employer notice of strike within 6 weeks before striking, or within 14 days of giving such notice, or before the expiry date of the strike specified in any such notice as foresaid, or during the pendency of any conciliation proceedings before a conciliation officer and 7 days after the conclusion of such proceedings. But herein it is important to notice that these arrangements don't forbid the labourers from demonstration, yet it expects them to satisfy the conditions before taking it to the streets. As held in the case of Balarpur Collieries Co. versus the Presiding Officer, Central Government, Industrial Tribunal 1972, it was held if a person was employed in a public utility services, then he/she cannot go for a strike without the consent and gathering the procedures which must be satisfied in the provisions. There are certain essentials necessary to go for strike. The first one is cessation of work. Cessation means abandonment, stoppage of work, or reluctance to perform the duties of their posts. It is an important characteristic of the strike. Refusal to continue to work that the employees are required to do. The cessation of work must be voluntary and temporary. Permanent cessation of work results in termination of employment contract. The cessation of work must be by persons employed in any industry. It means that the establishment should be industry with the definition of industry under the provided definition of Industrial Dispute Act 1947. The strikes must have acting in combinations. Individuals' workers' work stoppage do not constitute to a strike. Thus, a strike implies cessation of work by number of employees under common understanding. Unless the common intention of number of workers is proved, it would not amount to strike. The strike must be an result of industrial dispute. An industrial dispute arises from disagreement and conflict between employer and employers, employers and workmen, workmen and workmen. The dispute or disagreement ought to be related to employment, non-employment, terms of employment, conditions and services of any person. The dispute or difference under section 2K must be real and substantial differences with an element of persistence and continuity until resolved. The dispute or differences, if not resolved, is likely to endanger the peace of industry or any community. In Bangalore Water Supply and Sewage Board versus Rajappa 1978, the Supreme Court interpreted the definition of industry as covering both private and government industries. Thus, all industries, irrespective of their status, whether they are owned and run by state or by entrepreneurs, are covered under Industrial Dispute Act of 1947. Basic causes of strikes are, like if we look into the recent cases of strikes that have been taken place in the coming years, are related to low wages, better working conditions, holidays and leaves without pay, hours of working, wrongful discharge of workmen, leaves with bonus, profit sharing, provident fund and gratuity. There are very different types of strikes. Those are general strike, stay-in strike or sit-down strike, go-slow strike, hunger strike, pen-down strike. So the stay-in or stay-down strike basically means where the workers decide not to come to the company or the industry to not work, where they completely stop the work for certain days. Go-slow strike refers to when the workers intentionally decide to work slowly so that it harms the industry and the worker or the employers. Hunger strike is when the employees come together and sit down and do not eat for certain days so that their wishes are taken into consideration. Few instances of strike in India are: in March 2012, nurses employed by different hospitals in Chennai went to strike for 7 days, demanding from the hospital management to hike off basic wages up to Rs 15,000, apart from leave benefits and annual increments. All well-known hospitals like Apollo, Fortis, Max, etc. came to standstill because of strike. The other cases: in January 2014, Kingfisher employees went on hunger strike due to non-payment of salary for 17 days. Lastly, in September 2016, Tens of millions of Indian workers in public sector went on strike demanding higher wages. Banks and power stations were kept shut and public transportation system froze in some of the other states. Later, the government considered the demands and increased the wages. It was world's largest strike ever. There are certain procedures you need to follow to commence a strike. Proposal to go on strike should be intimate to management by a way of prior notice, that is 14 days stipulated time period, which should be given to the management to respond or to react so as to avoid strike. During this 14 days time, no workman should go on strike. Only after expiry of the 14 days and management fails to respond or to resolve issues within the 14 days, workers can go on strike on the fixed date of giving a notice. Such strike should be done before the expiry of these 6 weeks only. According to section 22, clause 1, no person employed in public utility service shall go on strike in breach of contract without giving to the employer notice of strike as hereinafter provided within 6 weeks before striking, or within 14 days of giving such notice. See, before the expiry date of strike specified in any such notice as foresaid. Lastly, during the pendency of any conciliation proceedings before a conciliation officer and 7 days after the conclusion of such proceedings. Now that we know all the rights workers get, there are certain rights employer do get, and they use the power through lockouts. Lockout is basically a work stoppage in which employer prevents employee from working. It is declared by employer to put pressure on their workers to come to their way by consensus about settlements of issues led to the lockout. According to Industrial Dispute Act 1947, lockout under section 2L means the temporary closing of a place of employment or suspension of the work or the refusal by an employer to continue employ and number of persons employed by him. Lockout is anesthesis of strike, which is basically opposite of strike. Management of Karibetta versus Rajanikam and others on 24th March 1960, Supreme Court of India observed as followed. Just as strike is a weapon available to the employees for enforcing their industrial demands, a lockout is a weapon available to employer to persuade by a coercive process the employees to see his point of view and accept his demands. There are various reasons behind a lockout, and those are disputes or clashes between workers and management. Illegal strikes, irregular strikes, or continuous strikes by workers may lead to lockout of factory or industry. External environment disturbance due to unstable government may lead to lockout of factories and industries. There are certain procedures that you need to follow for lockout. According to section 22, subclause 2, no person employed in public utility service shall go on lockout in breach of contract. A. Without giving to the employer notice of lockdown as herein provided within 6 weeks before lockout or 14 days of giving such notice. C. Before the expiry date of lockout specified in any such notice foresaid or during the pendency of any conciliation proceedings before a conciliation officer and 7 days after the conciliation of such proceeding. One of the major landmark cases of lockout is Lakshmi Das Sugar Mills Limited versus P.T. Ramsaraf, 1956. In this case, 76 workers of the appellate company went on a strike in support of dismissed co-worker. The general manager of the company makes an effort so that the workers resume their work. But after making certain efforts, in the end, he suspends them until further notice. One day, after the midday recess, the workers forcefully enter the mills, leading to the call of police to maintain peace. After all this, charges of misconduct and insubordination were framed against the workers. This further led to an open inquiry by general manager. But the workers' non-cooperation during this inquiry made the management take the step of dismissing the workers. However, due to a pending appeal, the company was made to seek permission from the Labour Appellate Tribunal to dismiss the workers. The main dispute in this case was whether the suspension and prevention of workers from working after midday constituted a lockout or no. The Supreme Court of India in this case gave the decision in favor of the company by stating that the conduct of company did not meet the definition of lockout. And even if it is considered a lockout, it was because of the consequences of an illegal strike conducted by the workers. And against an illegal strike, the employer has no right to do lockout. There is no need to obtain permission from the appellate tribunal under section 22 of the Act to declare lockout. The court also rejected the contention that the lockout amounts to punishment, as it was response to non-cooperation of the workers themselves. There are certain prohibitions to lockout and strikes under Industrial Dispute Act. Under section 23, no workman who is employed in any industrial establishment shall go on strike in breach of contract, and no employer of any such workman shall declare a lockout. First, during the pendency of conciliation proceedings before a board and 7 days after the conclusion of such proceedings. Second, during the pendency of proceedings before a labour court, tribunal or national tribunal, and 2 months after the conclusion of such proceedings. Third, during the pendency of arbitration proceedings before an arbitrator and 2 months after the conclusion of such proceedings, where a notification has been issued under subsection 3A of section 10A. During any period in which settlement or award is in operation in respect of any matter covered under the settlement of award. Now that we know what all strikes and lockouts have prohibitions, procedures, there are certain penalties that go on from section 26 to 30. Penalty for illegal strikes and lockouts under section 26 of Industrial Dispute Act says any workman who commences, continues or otherwise acts in furtherance of any strike which is illegal under this act shall be punishable with imprisonment up to term which may extend to 1 month or fine which may extend to 50 rupees or both. Any employer who commences, continues or otherwise acts in furtherance of a lockout which is illegal under this act shall be punishable with imprisonment for a term which may extend up to 1 month or fine which may extend to 1000 rupees or with both. Section 27th of Industrial Dispute Act 1947 deals with penalty for instigation. This act provides penalty for imprisonment which may extend up to 6 months or fine of rupees 1000 or both against any person who instigates or incites other person to take a part, otherwise act in furtherance of a lockout that is declared illegal under this act. Section 28 deals with penalty for giving financial aid to illegal strikes and lockouts. This act provides a penalty for the act which is prohibited under section 25 of the same act. Thus, any person who willingly supplies money that would be used in direct support for an illegal lockout would be punished for imprisonment which would extend up to 6 months and fine up to rupees 1000 or with both. Section 29 of the Industrial Dispute Act deals with penalty for breach of settlement or award. Any person who commits breach of any terms of any settlements or awards which is binding to him under this act shall be punishable with imprisonment of term which may extend up to 6 months or with both, and where the breach is continuing one, with a further fine which may extend up to 200 rupees for every day during which the breach continues after the conviction of first. Section 30 of the Industrial Dispute Act deals with penalty for disclosing confidential information. Any person who willfully discloses that such information is referred to in section 21 in the contravention of the provisions of the section shall, on complaint made by or on behalf of the trade union or individual business affected, be punishable with imprisonment for up to term which may extend to 6 months or with fine which may extend to 1000 rupees or both. Strikes and lockouts both are powerful terms in realm of the labor relations, each serving as a mean for employees and employer to assert their interest and leverage negotiations. While both disrupt workplace operations, they differ They differ fundamentally in their initiation, purpose, and legal implications. The difference between strikes and lockouts is not merely procedural. They represent a fundamental distinction in perspective. Strike embodies the collective will of workers, seeking to balance the scale of power in the workplace. Lockout, conversely, reflect the employer's exercise of authority, often with the aim of achieving favorable outcome in negotiations. Thus, we can conclude that strikes and lockouts are effective weapons for both employers and employees who are engaged in process of collective bargaining, provided that such weapons are utilized lawfully and ethically. Thank you.
Siddhi, thank you very much. It was a nice overview of the Industrial Dispute Act, and we have nicely covered what is strike, what is lockouts, the difference between two, and the various punishments as well as the procedures required to do a strike or a lockout. So, thank you very much, and a small token from Hammurabi to you.
Thank you, sir.